Court cases are supposed to settle disputes between parties. Sometimes they end up changing the entire legal system and creating rights that affect millions of people for generations. 1. Brown v. Board of Education, 1954, fundamentally changed American law by declaring racial segregation in public schools unconstitutional. Before this case, the separate but equal doctrine from Plessy v. Ferguson, 1896, had allowed legal segregation for nearly 60 years. Schools across the South were segregated by law, with black students attending separate, underfunded schools. Linda Brown was a black student in Topeka, Kansas, who had to walk miles to her segregated school, while a white school was much closer to her home. Her father, Oliver Brown, sued the Board of Education, arguing that separate schools were inherently unequal and violated the 14th Amendment's Equal Protection Clause. The case was combined with similar cases from other states. The Supreme Court heard arguments about whether separate facilities could ever be truly equal. The court unanimously ruled that separate educational facilities are inherently unequal, and that segregation in public schools violated the Constitution. Chief Justice Earl Warren wrote the opinion stating that segregation generated a feeling of inferiority that affected children's motivation to learn. The decision didn't just change school policy, it established the legal principle that racial segregation itself was unconstitutional, laying groundwork for the entire civil rights movement. The ruling led to massive resistance in the South, requiring federal troops to enforce integration in some areas. It took years and additional cases to fully implement, but Brown v. Board of Education permanently changed American law by establishing that government-enforced racial segregation violated constitutional rights. The case created precedent that extended beyond schools to all public accommodations and government activities, fundamentally altering American society. 2. Miranda v. Arizona, 1966, created the Miranda rights that police must read to suspects before questioning. Ernesto Miranda was arrested in Phoenix for kidnapping and rape. During police interrogation, he confessed to the crimes without being told he had a right to remain silent or a right to an attorney. His confession was used to convict him at trial. Miranda's lawyers argued that his Fifth Amendment right against self-incrimination and Sixth Amendment right to counsel had been violated because he wasn't informed of these rights before being interrogated. The Supreme Court agreed in a 5-4 decision. Chief Justice Earl Warren wrote that police must inform suspects of their rights before custodial interrogation. The court established specific warnings that must be given: the right to remain silent, that anything said can be used against them in court, the right to an attorney, and that an attorney will be provided if they can't afford one. If these warnings aren't given, statements made during interrogation can't be used as evidence. The ruling fundamentally changed police procedure across America. Every police department had to implement Miranda warnings. The phrase, "you have the right to remain silent," became embedded in American culture through TV and movies. The case created a clear constitutional requirement for protecting suspects' rights during interrogation. Ironically, Ernesto Miranda was retried without his confession and convicted again based on other evidence. He was later murdered in a bar fight, and the suspect was read his Miranda rights, the very rights created by Miranda's case. 3. Roe v. Wade, 1973, established a constitutional right to abortion and fundamentally changed reproductive rights law. Jane Roe, a pseudonym for Norma McCorvey, was a pregnant woman in Texas where abortion was illegal except to save the mother's life. She sued Texas District Attorney Henry Wade, arguing that abortion laws violated her constitutional rights. The case reached the Supreme Court, which had to decide whether the Constitution protected a right to abortion. In a 7-2 decision, the court ruled that the Constitution's right to privacy extended to a woman's decision to have an abortion. Justice Harry Blackmun wrote the majority opinion establishing a trimester framework. States couldn't regulate abortion in the first trimester, could regulate to protect maternal health in the second trimester, and could prohibit abortion in the third trimester, except when necessary for the mother's health. The decision invalidated abortion laws in 46 states and created a constitutional framework for abortion rights that lasted nearly 50 years. The case became one of the most controversial Supreme Court decisions in American history, creating ongoing political battles. It established privacy as a constitutional principle in reproductive decisions. The legal framework from Roe governed abortion law until it was overturned by Dobbs versus Jackson Women's Health Organization in 2022, but for 5 decades it was the controlling law affecting millions of women's reproductive choices. 4. Gideon v. Wainwright, 1963, established the right to counsel for criminal defendants who can't afford lawyers. Clarence Earl Gideon was charged with breaking into a pool hall in Florida. He was poor and couldn't afford a lawyer. He asked the judge to appoint one for him, but Florida law only provided free lawyers in capital cases. Gideon represented himself at trial, was convicted, and sentenced to 5 years in prison. From prison, he handwrote a petition to the Supreme Court, arguing that his Sixth Amendment right to counsel had been violated. The Supreme Court agreed to hear his case and appointed prominent lawyer Abe Fortas to represent him. The court unanimously ruled that the Sixth Amendment's guarantee of counsel is fundamental and essential to a fair trial, and that states must provide lawyers to criminal defendants who can't afford them. Justice Hugo Black wrote that lawyers in criminal courts are necessities, not luxuries. The decision required every state to provide public defenders or appointed counsel for indigent defendants. This fundamentally changed the criminal justice system by creating the public defender system we have today. Gideon himself got a new trial with a lawyer and was acquitted. The case established that the right to counsel applies to state prosecutions through the 14th Amendment, creating a national standard for criminal procedure. 5. Marbury v. Madison, 1803, established the principle of judicial review, giving courts the power to declare laws unconstitutional. After John Adams lost the 1800 election, he appointed many Federalist judges in his final days as president. William Marbury was appointed as a Justice of the Peace, but his commission wasn't delivered before Thomas Jefferson took office. Jefferson's Secretary of State, James Madison, refused to deliver the commission. Marbury sued, asking the Supreme Court to force Madison to deliver it. Chief Justice John Marshall faced a dilemma. If the court ordered Madison to deliver the commission and he refused, the court would look weak. But if the court didn't help Marbury, it would seem to be avoiding its duty. Marshall's brilliant solution was to rule that while Marbury had a right to his commission, the law giving the Supreme Court power to issue such orders was itself unconstitutional. In doing so, Marshall established that the Supreme Court has the power to review laws and declare them unconstitutional if they conflict with the Constitution. This principle of judicial review wasn't explicitly in the Constitution, but Marshall argued it was implied. The decision gave the judiciary power to check the legislative and executive branches, fundamentally shaping the balance of power in American government. Judicial review became the foundation of constitutional law, allowing courts to strike down laws and government actions that violate the Constitution. This single case created the Supreme Court's role as the ultimate interpreter of constitutional law. 6. Loving v. Virginia, 1967, struck down laws banning interracial marriage and established marriage as a fundamental right. Richard Loving, a white man, and Mildred Jeter, a black woman, were married in Washington, D.C. in 1958 and returned to their home in Virginia. Virginia's anti-miscegenation law made interracial marriage a felony. The Lovings were arrested in their bedroom, convicted, and sentenced to a year in prison. The judge suspended the sentence on condition they leave Virginia and not return together for 25 years. The judge stated Almighty God created the races white, black, yellow, Malay, and red, and he placed them on separate continents. The fact that he separated the races shows that he did not intend for the races to mix. The Lovings moved to D.C. but sued to overturn Virginia's law. The Supreme Court unanimously struck down Virginia's anti-miscegenation statute and similar laws in 15 other states. Chief Justice Earl Warren wrote that the freedom to marry is a fundamental right, and that laws restricting marriage based on race violated both the equal protection and due process clauses of the 14th Amendment. The decision invalidated all remaining laws against interracial marriage in the United States. It established that marriage is a fundamental liberty and that racial classifications are inherently suspect. The case became foundational for later marriage equality cases. 7. New York Times. Coher v. Sullivan, 1964, revolutionized libel law and protected freedom of the press. The New York Times published an advertisement criticizing Montgomery, Alabama police for their treatment of civil rights protesters. L.B. Sullivan, a Montgomery city commissioner, sued for libel, claiming the ad damaged his reputation, even though he wasn't named. An Alabama jury awarded Sullivan $500,000. The Supreme Court reversed the decision and created a new constitutional standard for libel. The court ruled that public officials suing for defamation must prove actual malice, that the statement was made with knowledge it was false or with reckless disregard for the truth. Justice William Brennan wrote that debate about public issues should be uninhibited, robust, and wide open, and may include vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials. The decision made it much harder for public officials to win libel cases and gave the press greater freedom to investigate and criticize government. It protected political speech and created breathing space for vigorous public debate. The actual malice standard became a cornerstone of First Amendment law, applying not just to traditional media but to all forms of public discourse about public figures and officials. 8. Mapp v. Ohio, 1961, established the exclusionary rule preventing illegally obtained evidence from being used in state prosecutions. Cleveland police broke into Dalry Mapp's home without a proper warrant, searching for a bombing suspect. They didn't find the suspect, but did find obscene materials, which were illegal in Ohio. Mapp was convicted of possessing obscene materials based on evidence from the illegal search. The Supreme Court ruled that evidence obtained through illegal searches violates the Fourth Amendment and cannot be used in state criminal prosecutions. The exclusionary rule had previously applied only to federal cases, but the court extended it to state prosecutions through the 14th Amendment. Justice Tom Clark wrote that allowing illegally obtained evidence would make the Fourth Amendment meaningless. The decision forced police departments across the country to follow constitutional search and seizure procedures or risk having their cases dismissed. It fundamentally changed police practices and criminal procedure, requiring search warrants and proper probable cause. The ruling gave teeth to Fourth Amendment protections by creating consequences for illegal searches. 9. Plessy v. Ferguson, 1896, established the separate but equal doctrine that legalized racial segregation for 6 decades. Homer Plessy, who was 1/8 black, deliberately sat in a whites-only railroad car in Louisiana to challenge segregation laws. He was arrested for violating Louisiana's Separate Car Act. Plessy argued the law violated the 13th and 14th Amendments. The Supreme Court ruled 7-1 that segregation laws were constitutional as long as facilities were equal. Justice Henry Brown wrote that the 14th Amendment could not have been intended to abolish distinctions based upon color or to enforce social as distinguished from political equality. The decision established separate but equal as legal doctrine, giving constitutional approval to Jim Crow laws across the South. This allowed legal segregation of schools, transportation, restaurants, bathrooms, and virtually all public spaces. The decision shaped American society for decades, creating a legally enforced racial caste system. Justice John Marshall Harlan's lone dissent became famous. Our Constitution is colorblind and neither knows nor tolerates classes among citizens. The case stood for 58 years until Brown v. Board overturned it. But Plessy's legacy of legally sanctioned segregation had devastating effects on generations of Black Americans. 10. Griswold v. Connecticut, 1965, established a constitutional right to privacy. Connecticut law prohibited the use of contraceptives, even by married couples. Estelle Griswold, executive director of Planned Parenthood, and Dr. Lee Buxton, a physician, were convicted for giving married couples information and medical advice on contraception. They challenged the law as unconstitutional. The Supreme Court struck down Connecticut's law and established that the Constitution contains an implied right to privacy. Justice William Douglas wrote that specific guarantees in the Bill of Rights have penumbras that create zones of privacy. The court found that various amendments combine to protect privacy in marital relations. The decision established privacy as a constitutional principle, even though the word privacy doesn't appear in the Constitution. This ruling became the foundation for later cases protecting reproductive rights, intimate relationships, and personal autonomy. The privacy right established in Griswold was cited as precedent in Roe v. Wade and other cases expanding individual liberties. 11. United States versus Nixon, 1974, established that the president is not above the law. President Richard Nixon refused to release tape recordings and documents requested during the Watergate investigation, claiming executive privilege. Special prosecutor Leon Jaworski subpoenaed the materials. Nixon's lawyers argued the president had absolute privilege to withhold information. The Supreme Court unanimously rejected this argument. Chief Justice Warren Burger wrote that while executive privilege exists, it's not absolute and must yield to the needs of criminal justice. The court ordered Nixon to release the tapes. The recordings revealed Nixon's involvement in covering up the Watergate break-in. Within weeks, Nixon resigned rather than face certain impeachment. The case established that no one, including the president, is above the law. It limited executive privilege and affirmed that the judicial branch can review and overrule presidential claims of privilege. The decision preserved the rule of law and the system of checks and balances. 12. Brown VR Entertainment Merchants Association, 2011, established that video games are protected speech under the First Amendment. California passed a law prohibiting the sale of violent video games to minors and requiring warning labels. The video game industry challenged the law. The Supreme Court struck down California's law 7-2. Justice Antonin Scalia wrote that video games qualify for First Amendment protection, just like books, movies, and other forms of expression. The court found that while obscenity can be restricted for minors, violence alone isn't enough to justify censorship. The decision protected video games as a creative medium and prevented states from censoring games based on violent content. It established that new forms of media receive the same constitutional protection as traditional media. 13. Texas v. Johnson, 1989, established that flag burning is protected symbolic speech. Gregory Lee Johnson burned an American flag at the 1984 Republican National Convention to protest Reagan's policies. He was arrested and convicted under Texas law prohibiting desecration of the American flag. The Supreme Court ruled 5-4 that flag burning is expressive conduct protected by the First Amendment. Justice William Brennan wrote that if there is a bedrock principle underlying the First Amendment, it is that the government may not prohibit the expression of an idea simply because society finds the idea itself offensive. The decision invalidated flag desecration laws in 48 states. It established that the government can't prohibit speech just because people find it offensive, even when it involves national symbols. The ruling was controversial but affirmed that free speech includes the right to express unpopular views. Congress attempted to pass a constitutional amendment to allow flag desecration laws, but it failed to get the required two-thirds vote. 14. Terry v. Ohio, 1968, established police authority to conduct stop and frisk searches. Cleveland detective Martin McFadden observed John Terry and others acting suspiciously, appearing to case a store for robbery. McFadden stopped them and patted down Terry, finding a concealed weapon. Terry argued the search violated the Fourth Amendment because McFadden lacked probable cause for arrest. The Supreme Court ruled that police can stop and frisk individuals based on reasonable suspicion of criminal activity, a lower standard than probable cause. Chief Justice Earl Warren wrote that police need the ability to protect themselves when investigating suspicious behavior. The decision balanced Fourth Amendment rights against police safety concerns. It created the legal framework for Terry stops that police use today. The ruling allows police to briefly detain and search individuals based on reasonable suspicion, fundamentally changing street-level police practices. 15. Obergefell v. Hodges, 2015, established marriage equality nationwide. James Obergefell sued Ohio for refusing to recognize his marriage to his dying partner, John Arthur, which had been performed in Maryland. The case was combined with challenges from several states. The Supreme Court ruled 5-4 that same-sex couples have a constitutional right to marry, and that states must recognize same-sex marriages performed in other states. Justice Anthony Kennedy wrote that marriage is a fundamental right, and denying it to same-sex couples violates the due process and equal protection clauses. The decision required all states to issue marriage licenses to same-sex couples and recognize such marriages performed elsewhere. It invalidated same-sex marriage bans in 13 states. The ruling completed a rapid legal transformation. Same-sex marriage went from illegal nationwide to a constitutional right in roughly a decade. The case extended the principle from Loving v. Virginia that marriage is a fundamental right to same-sex couples. 16. Citizens United versus Federal Election Commission, 2010, revolutionized campaign finance law. Citizens United, a conservative organization, wanted to air a film critical of Hillary Clinton during the 2008 primary campaign. Federal law prohibited corporations from making independent expenditures for electioneering communications within 30 days of a primary. The Supreme Court ruled 5-4 that corporate funding of independent political broadcasts can't be limited under the First Amendment. Justice Anthony Kennedy wrote that political speech doesn't lose First Amendment protection based on the speaker's corporate identity. The court held that independent expenditures don't cause corruption or the appearance of corruption. The decision overturned previous precedent and transformed campaign finance. It allowed unlimited corporate and union spending on political campaigns through independent expenditures. The ruling led to the rise of super PACs and dramatically increased money in politics. Critics argued it allowed wealthy interests to dominate elections, while supporters said it protected political speech. 17. Furman v. Georgia, 1972, temporarily ended the death penalty in America. William Furman was convicted of murder during a burglary and sentenced to death. The Supreme Court ruled 5-4 that the death penalty as then applied violated the Eighth Amendment's ban on cruel and unusual punishment. The court found that death penalty laws gave juries unlimited discretion, resulting in arbitrary and discriminatory sentencing. All 9 justices wrote separate opinions, but the result was that death penalty laws in 39 states were invalidated. Over 600 death row inmates had their sentences commuted. The decision didn't declare the death penalty inherently unconstitutional, but found that its application was. States responded by rewriting death penalty laws to include guided discretion and automatic appellate review. In Gregg v. Georgia, 1976, the court approved new death penalty statutes. While Furman didn't permanently end capital punishment, it fundamentally changed how death penalty laws are structured. 18. Tinker v. Des Moines Independent Community School District, 1969, established students' free speech rights in schools. Mary Beth Tinker and other students wore black armbands to school to protest the Vietnam War. School officials prohibited the armbands and suspended students who wore them. The students sued, arguing their First Amendment rights were violated. The Supreme Court ruled 7-2 that students don't shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. Justice Abe Fortas wrote that schools can only restrict student speech if it substantially disrupts school operations or invades others' rights. Mere discomfort or disagreement isn't enough to justify censorship. The decision established that students have constitutional rights in schools, though not identical to adults' rights. It created the framework for balancing school authority against student expression that governs student speech cases today. 19. Katz v. United States, 1967, established Fourth Amendment privacy protections for electronic communications. FBI agents attached an electronic listening device to the outside of a public phone booth to record Charles Katz's gambling-related phone calls. Katz was convicted based on these recordings. The Supreme Court ruled that the Fourth Amendment protects people, not just places, and that warrantless wiretapping violated Katz's privacy rights, even in a public phone booth. Justice Potter Stewart wrote that the Fourth Amendment protects what a person seeks to preserve as private. The decision established that people have a reasonable expectation of privacy that the Fourth Amendment protects. This standard became the test for Fourth Amendment cases and extended protections to electronic communications. The ruling meant that government surveillance of private communications requires a warrant, fundamentally shaping privacy law in the modern age. 20. New York Times Comer v. United States, 1971, the Pentagon Papers case, established limits on prior restraint of publication. The New York Times and Washington Post began publishing classified documents about U.S. involvement in Vietnam. The Nixon administration sought injunctions to stop publication arguing national security. The Supreme Court ruled 6-3 that the government couldn't prevent publication. The court held that any system of prior restraints bears a heavy presumption against its constitutional validity, and the government hadn't met the heavy burden required to justify it. The decision affirmed that free press is essential to democracy and that government censorship requires extraordinary justification. It established that even classified information can be published if doing so doesn't present a clear and present danger. The ruling protected investigative journalism and government accountability. 21. Baca v. Regents of the University of California, 1978, established the legal framework for affirmative action. Alan Baca, a white applicant, was rejected by UC Davis Medical School, while minority applicants with lower scores were admitted through a special admissions program that reserved 16 of 100 spots for minorities. Baca sued, claiming racial discrimination. The Supreme Court's complex decision produced 6 separate opinions, but held that rigid racial quotas violate the Equal Protection Clause, while race can be one factor among many in admissions decisions. Justice Lewis Powell's controlling opinion said that achieving diverse student bodies is a compelling interest, but quotas aren't allowed. The decision struck down UC Davis's quota system but upheld consideration of race in admissions. It created the framework for affirmative action that lasted decades. Race-conscious admissions are allowed, but quotas aren't. The ruling tried to balance equal protection principles with educational diversity goals. 22. Gideon v. Wainwright, 1963, established the right to counsel for criminal defendants who can't afford lawyers. Clarence Earl Gideon was charged with breaking into a pool hall in Florida. He was poor and couldn't afford a lawyer. He asked the judge to appoint one for him, but Florida law only provided free lawyers in capital cases. Gideon represented himself at trial, was convicted, and sentenced to 5 years in prison. From prison, he handwrote a petition to the Supreme Court, arguing that his Sixth Amendment right to counsel had been violated. The Supreme Court agreed to hear his case and appointed prominent lawyer Abe Fortas to represent him. The court unanimously ruled that the Sixth Amendment's guarantee of counsel is fundamental and essential to a fair trial, and that states must provide lawyers to criminal defendants who can't afford them. Justice Hugo Black wrote that lawyers in criminal courts are necessities, not luxuries. The decision required every state to provide public defenders or appointed counsel for indigent defendants. This fundamentally changed the criminal justice system by creating the public defender system we have today. Gideon himself got a new trial with a lawyer and was acquitted. 23. District of Columbia v. Heller, 2008, established an individual right to bear arms. Washington, D.C. banned handgun possession and required other firearms to be kept unloaded and disassembled. Dick Heller, a D.C. special police officer, challenged the law. The Supreme Court ruled 5-4 that the Second Amendment protects an individual right to possess firearms for lawful purposes like self-defense in the home. Justice Antonin Scalia wrote that the amendment's prefatory clause about a militia doesn't limit the operative clause protecting the right to keep and bear arms. The decision struck down D.C.'s handgun ban and established for the first time that the Second Amendment protects individual gun ownership separate from militia service. The ruling fundamentally changed gun rights law and led to challenges to gun control laws nationwide. It resolved a long-standing debate about whether the Second Amendment protects individual or collective rights. 24. Engel vs. Vitale, 1960, banned state-sponsored school prayer. New York's Board of Regents composed an official prayer for public school students. Almighty God, we acknowledge our dependence upon Thee, and we beg Thy blessings upon us, our parents, our teachers, and our country. Even though the prayer was voluntary and non-denominational, parents challenged it. The Supreme Court ruled 6-1 that government-written prayers in public schools violate the Establishment Clause of the First Amendment. Justice Hugo Black wrote that it is no part of the business of government to compose official prayers. The decision held that state-sponsored religious activities in schools are unconstitutional, even if voluntary. The ruling sparked massive controversy and calls to impeach the justices, but it established the principle of separation of church and state in public education. The decision didn't ban student-led prayer, but prohibited school-organized religious activities. 25. Weeks v. United States, 1914, created the exclusionary rule for federal prosecutions. Police entered Fremont Weeks's home without a warrant and seized papers used to convict him of transporting lottery tickets through mail. The Supreme Court ruled that illegally seized evidence cannot be used in federal criminal prosecutions. Justice William Day wrote that allowing such evidence would make the Fourth Amendment meaningless. The decision established the exclusionary rule. Evidence obtained through illegal searches is inadmissible in court. This gave teeth to Fourth Amendment protections by creating consequences for illegal searches. The ruling initially applied only to federal cases. Mapp v. Ohio later extended it to state prosecutions. The exclusionary rule remains controversial, but is a fundamental part of constitutional criminal procedure. 26. Schenck v. United States, 1919, established that free speech isn't absolute and created the clear and present danger test. Charles Schenck distributed leaflets urging draft resistance during World War I. He was convicted under the Espionage Act. The Supreme Court unanimously upheld his conviction. Justice Oliver Wendell Holmes wrote that speech creating a clear and present danger of evils that Congress has the right to prevent can be restricted. Holmes famously wrote that the most stringent protection of free speech would not protect a man in falsely shouting fire in a theater and causing a panic. The decision established that First Amendment protections have limits when speech poses immediate danger. While later cases modified the clear and present danger test, Schenck established that free speech isn't unlimited. The case shaped how courts balance free expression against government interests. 27. Griswold v. Connecticut, 1965, established a constitutional right to privacy. Connecticut law prohibited the use of contraceptives, even by married couples. Estelle Griswold, executive director of Planned Parenthood, and Dr. Lee Buxton were convicted for giving married couples contraception information. The Supreme Court struck down Connecticut's law, finding an implied constitutional right to privacy. Justice William Douglas wrote that specific Bill of Rights guarantees create penumbras forming zones of privacy. The decision established privacy as a constitutional principle, becoming foundation for cases protecting reproductive rights, intimate relationships, and personal autonomy. The privacy right from Griswold was cited in Roe v. Wade and other landmark cases expanding individual liberties. 28. McCulloch v. Maryland, 1819, established federal supremacy over states and broadly interpreted federal powers. Maryland attempted to tax the second bank of the United States. James McCulloch, a bank cashier, refused to pay. The case asked whether Congress had power to create a national bank and whether states could tax federal institutions. Chief Justice John Marshall ruled that the Constitution's necessary and proper clause gives Congress implied powers beyond those explicitly listed. The court held that states cannot tax federal institutions, establishing federal supremacy. Marshall wrote, "The power to tax involves the power to destroy, and states can't destroy federal institutions through taxation." The decision broadly interpreted federal authority and limited state power to interfere with federal operations. It fundamentally shaped federalism and the balance of power between national and state governments. 29. Heart of Atlanta Motel Vibas United States, 1964, upheld the Civil Rights Act and ended segregation in public accommodations. The Heart of Atlanta Motel refused to serve black guests and challenged the Civil Rights Act of 1964 as exceeding Congress's authority. The Supreme Court unanimously upheld the act under Congress's power to regulate interstate commerce. The court found that racial discrimination in hotels and motels affects interstate travel and commerce, justifying federal regulation. The decision gave constitutional approval to the Civil Rights Act's public accommodations provisions, ending legal segregation in hotels, restaurants, and other businesses. Combined with similar rulings, it validated federal civil rights legislation and ended Jim Crow in public spaces. 30. Korematsu v. United States, 1944, upheld Japanese-American internment during World War II but was later repudiated. Fred Korematsu defied the military order requiring Japanese Americans to report to internment camps. He was convicted of violating the order. The Supreme Court ruled 6-3, that internment was justified by military necessity during wartime. Justice Hugo Black wrote that pressing public necessity may justify restrictions on civil liberties. The decision allowed the forced relocation and detention of over 110,000 Japanese Americans, most of whom were citizens. Justice Frank Murphy's dissent called it legalization of racism. The decision stood for decades as precedent for government power in emergencies. In 1983, a federal court vacated Korematsu's conviction, finding that the government had suppressed evidence that internment wasn't militarily necessary. In 2018, the Supreme Court formally repudiated Korematsu while upholding the Trump travel ban, calling the internment decision gravely wrong. The case serves as a warning about civil liberties during wartime and remains one of the Supreme Court's most criticized decisions. 31. Planned Parenthood v. Casey, 1992, modified but preserved abortion rights established in Roe v. Wade. Pennsylvania enacted restrictions on abortion, including a 24-hour waiting period, informed consent requirements, parental consent for minors, and spousal notification. Planned Parenthood challenged these provisions. The Supreme Court issued a complex decision that abandoned Roe's trimester framework, but preserved the core right to abortion before viability. The court created a new standard. States can regulate abortion as long as they don't create an undue burden on women seeking abortions. The decision upheld most of Pennsylvania's restrictions, but struck down spousal notification. Justices O'Connor, Kennedy, and Souter wrote a joint opinion stating, "The essential holding of Roe v. Wade should be retained and once again reaffirmed." The undue burden standard became the new framework for abortion cases until Dobbs v. Jackson, 2022, overturned both Roe and Casey. 32. Shelby County v. Holder, 2013, struck down key portions of the Voting Rights Act. The Voting Rights Act of 1965 required certain states with histories of discrimination to get federal approval, pre-clearance, before changing voting laws. Shelby County, Alabama, challenged this requirement as outdated. The Supreme Court ruled 5 out of 4 that the formula determining which jurisdictions need pre-clearance was unconstitutional because it was based on decades-old data. Chief Justice John Roberts wrote that things have changed dramatically since 1965. The decision effectively ended federal pre-clearance requirements. Within hours, some previously covered states began implementing voting changes that had been blocked. The ruling sparked controversy about voting rights protections and led to new voting restrictions in many states. Critics argued it gutted the Voting Rights Act, while supporters said it recognized changed conditions in the South. 33. Gibbons v. Ogden, 1824, broadly interpreted Congress's power to regulate interstate commerce. New York granted a monopoly on steamboat operations in state waters. Thomas Gibbons held a federal license to operate boats, but violated the New York monopoly. Aaron Ogden, who held the monopoly, sued. The Supreme Court ruled that federal law supersedes state law and broadly defined commerce to include navigation and intercourse between states. Chief Justice John Marshall wrote that Congress's commerce power extends to activities affecting multiple states, not just buying and selling. The decision established federal authority over interstate commerce and limited state power to restrict it. This broad interpretation of the Commerce Clause became the basis for extensive federal regulation of economic activity for the next 2 centuries. 34. New Jersey v. TLO, 1985, established Fourth Amendment standards for school searches. A teacher caught a student smoking in the bathroom and brought her to the principal. The principal searched her purse, finding marijuana and evidence of drug dealing. TLO argued the search violated her Fourth Amendment rights. The Supreme Court ruled that the Fourth Amendment applies to school searches, but with a lower standard than police searches. The court held that school officials need only reasonable suspicion, not probable cause, to search students. The decision balanced students' privacy rights against schools' need to maintain order. It established that school searches don't require warrants, but must be reasonable in scope and based on reasonable suspicion of rule violations. The ruling gave school officials more latitude than police while still requiring constitutional justification for searches. 35. Kelo v's City of New London, 2005, controversially expanded eminent domain powers. New London, Connecticut, used eminent domain to take private homes for economic development that would benefit Pfizer Pharmaceutical Company. Susette Kelo and other homeowners refused to sell. The Supreme Court ruled 5 out of 4 that economic development qualifies as public use under the Fifth Amendment's Takings Clause. Justice John Paul Stevens wrote that cities can take property for projects that benefit the community economically. The decision sparked outrage and controversy, as many saw it as allowing government to take private property to benefit private developers. Justice Sandra Day O'Connor's dissent warned nothing is to prevent the state from replacing any Motel 6 with a Ritz-Carlton. The ruling led to widespread backlash, and many states passed laws limiting eminent domain for economic development. The economic development project in New London ultimately failed and the land remains vacant. 36. Lochner v. New York, 1905, struck down labor regulations and created an era of economic liberty jurisprudence. New York passed a law limiting bakery workers to 60 hours per week. Joseph Lochner was convicted of violating the law. The Supreme Court ruled 5 to 4 that the law violated freedom of contract under the 14th Amendment's Due Process Clause. Justice Rufus Peckham wrote that the law interfered with the right to contract. The decision began the Lochner era, where courts struck down many labor and economic regulations as violations of economic liberty. For 3 decades, the court invalidated minimum wage laws, price controls, and labor protections. The approach was abandoned during the New Deal, when the court recognized greater government power to regulate the economy. Justice Oliver Wendell Holmes's dissent became famous. The 14th Amendment does not enact Mr. Herbert Spencer's social statics, criticizing the majority for imposing economic philosophy into constitutional interpretation. 37. Hamdi v. Rumsfeld, 2004, established that U.S. citizens detained as enemy combatants can challenge their detention. Yasser Hamdi, an American citizen, was captured in Afghanistan and detained indefinitely without charges as an enemy combatant. His father sued, arguing that detaining a citizen without charges violates due process. The Supreme Court ruled that while Congress authorized detention of enemy combatants, due process requires that citizens have the ability to challenge their detention before a neutral decision-maker. Justice Sandra Day O'Connor wrote, "A state of war is not a blank check for the president when it comes to the rights of the nation's citizens." The decision balanced national security needs against constitutional rights, establishing that even during wartime, citizens retain the right to contest their detention. 38. Dred Scott v. Sanford, 1857, ruled that black people couldn't be citizens, helping trigger the Civil War. Dred Scott was enslaved but had lived in free states and territories. He sued for freedom, arguing that residence in free territory made him free. Chief Justice Roger Taney wrote that black people had no rights which the white man was bound to respect, and couldn't be citizens. The court ruled that Congress couldn't prohibit slavery in territories, invalidating the Missouri Compromise. The decision inflamed tensions between North and South and is considered one of the worst Supreme Court decisions. It denied citizenship and rights to all black people, enslaved or free. The ruling was overturned by the 13th and 14th Amendments after the Civil War. Dred Scott remains a historical example of how courts can entrench injustice. 39. Brandenburg v. Ohio, 1969, established the modern standard for prohibiting speech that incites violence. Clarence Brandenburg, a KKK leader, was convicted under Ohio law for advocating violence at a rally where he made racist and threatening statements. The Supreme Court unanimously reversed his conviction and created a new test. Government can only prohibit speech if it's directed to inciting or producing imminent lawless action, and is likely to incite or produce such action. This replaced the clear and present danger test with a more speech-protective standard. The decision made it very difficult to prosecute speech, protecting even hateful or extreme expression, unless it directly incites immediate violence. Brandenburg became the standard for First Amendment cases involving dangerous speech. 40. Johnson v. Mintosh, 1823, established the legal doctrine that European discovery gave valid land titles. The case involved competing land claims from different sources. Chief Justice John Marshall ruled that European discovery gave title to land, regardless of Native American occupation. The decision established the doctrine of discovery as American law, that indigenous peoples' land rights were limited to occupancy and use, while European discoverers held ultimate title. The ruling provided legal foundation for taking Native American lands and has been used to justify centuries of dispossession. Modern scholars and Native American advocates criticize the decision as racist and based on discredited legal theories, but it remains part of American property law's foundation. 41. Bush vs. Gore, 2000, decided the 2000 presidential election. Florida's presidential vote was extremely close, with George W. Bush leading by about 500 votes. Al Gore requested recounts in several counties. Florida Supreme Court ordered a statewide manual recount. Bush appealed to the U.S. Supreme Court. The Supreme Court ruled 5-4 that the recount violated equal protection because different counties used different standards for evaluating ballots. The court also ruled 7-2 that there wasn't time to conduct a proper recount before the safe harbor deadline. The decision effectively ended the recounts and made Bush president. The ruling was controversial because it determined the presidency and because the court acknowledged the decision shouldn't be used as precedent. Critics argued the conservative justices acted politically to elect a Republican president. The case established that the Supreme Court could intervene in presidential elections under certain circumstances. 42. Worcester v. Georgia, 1832, recognized tribal sovereignty but was ignored by President Jackson. Georgia passed laws extending state jurisdiction over Cherokee territory in violation of treaties. Samuel Worcester, a missionary living in Cherokee Nation, was convicted of violating Georgia law by not having a state permit. The Supreme Court ruled that the Cherokee Nation was sovereign and Georgia law had no force in Cherokee territory. Chief Justice John Marshall wrote that Native American tribes are distinct political communities, having territorial boundaries within which their authority is exclusive. The decision should have protected Cherokee sovereignty and lands. President Andrew Jackson allegedly said, "John Marshall has made his decision, now let him enforce it," and refused to enforce the ruling. Georgia ignored the decision and the federal government proceeded with Cherokee removal, leading to the Trail of Tears. While the case established important principles of tribal sovereignty that later courts relied on, its immediate impact showed the limits of judicial power when other branches won't enforce decisions. 43. National Federation of Independent Business, Fris Sibelius, 2012, upheld the Affordable Care Act. The case challenged Obamacare's individual mandate, requiring people to buy health insurance or pay a penalty. Opponents argued Congress exceeded its Commerce Clause authority. The Supreme Court ruled 5-4 that while the mandate wasn't valid under the Commerce Clause, it was constitutional as a tax under Congress's taxing power. Chief Justice John Roberts wrote the surprising opinion upholding the law's core provision. The decision also limited Congress's power to expand Medicaid, ruling that conditioning all Medicaid funding on accepting expansion was unconstitutionally coercive to states. The ruling preserved the Affordable Care Act and extended health insurance to millions, but established limits on the Commerce Clause and federal spending power. Roberts's vote to uphold the law shocked observers and preserved Obama's signature legislative achievement. 44. Miller v. California, 1973, established the modern test for obscenity. Marvin Miller was convicted of mailing unsolicited sexually explicit material, violating California law. The Supreme Court created a 3-part test for determining whether material is obscene and thus unprotected by the First Amendment. 1. Whether the average person applying contemporary community standards would find the work appeals to prurient interest. 2. Whether it depicts sexual conduct in a patently offensive way. And 3. Whether the work lacks serious literary, artistic, political, or scientific value. Chief Justice Warren Burger wrote that obscenity is determined by local community standards, not national standards. The decision gave states more power to regulate pornography while protecting material with redeeming value. The Miller test remains the standard for obscenity prosecutions today. 45. And finally, Escobedo v. Illinois, 1964, established the right to counsel during interrogation, paving the way for Miranda. Danny Escobedo was arrested for murder and repeatedly asked to see his lawyer during interrogation. Police refused and continued questioning until he made incriminating statements. The Supreme Court ruled that once a criminal investigation focuses on a suspect and becomes accusatory, the suspect has a right to consult with counsel, and police must inform him of this right. Justice Arthur Goldberg wrote that the right to counsel is meaningless if it doesn't attach until trial. The decision established that the Sixth Amendment right to counsel applies during police interrogation, not just at trial. This case was a crucial step toward Miranda v. Arizona, which created the specific warnings police must give. Escobedo established the principle that counsel is needed to protect against coerced confessions, and that police interrogation is a critical stage requiring constitutional protection. The ruling fundamentally changed criminal procedure by extending the right to counsel backward from trial to the investigative stage when suspects are most vulnerable to pressure. The case recognized that what happens in the interrogation room can determine the outcome at trial, making legal representation essential at that stage. Escobedo's conviction was overturned, and his case became a building block for the broader protections established 2 years later in Miranda, creating the framework for protecting suspects' rights during the critical interrogation phase that exists today. The brutal truth about court cases changing laws is that individual lawsuits filed by ordinary people, often from prison, sometimes handwritten, occasionally by people who couldn't afford lawyers, have fundamentally shaped the legal system we live under today. These weren't just disputes between parties, they were battles over constitutional principles that would affect millions. These 45 cases created rights we take for granted. The right to a lawyer if you're accused of a crime, the right to remain silent, the right to privacy, the right to marry who you love, protection from illegal searches, and free speech protections. They ended segregation, protected the press, limited presidential power, and defined the relationship between government and citizens. Some of these decisions are celebrated as expanding freedom and justice. Others are controversial or have been repudiated as terrible mistakes. But all of them permanently changed the law, creating precedents that courts still cite and apply decades or centuries later. They prove that the legal system, while slow and imperfect, can evolve and that determined individuals can challenge unjust laws and sometimes win. The most remarkable aspect is how many of these transformative cases came from powerless people. Prisoners, racial minorities, students, the poor, who challenged government power and prevailed. Clarence Gideon handwrote a petition from prison that created the public defender system. Linda Brown's father sued a school board and ended legal segregation. Ernesto Miranda's interrogation created rights read to millions of suspects. Ordinary people in extraordinary circumstances changed the law for everyone. Subscribe if you want to remember that court cases have shaped the rights and freedoms we have today, that legal precedents established decades ago still govern modern life, and that sometimes a single lawsuit can permanently change society by creating laws and principles that last for generations.